Hi everyone. So today we have a session, a policy hack, a very important, relevant policy hack on GDPR, which everybody is hearing about, and it particularly impacts tech companies, companies which are targeting people and other businesses in the European Union. I have with me Siddharth from iSPIRT and Supratim from Khaitan. They are both experts in GDPR. Supratim is an expert in GDPR. He has been closely monitoring not only GDPR but also the proposed data privacy law in India, and therefore he is going to share important insights on GDPR, how it impacts Indian tech companies, what should be done to sort of ensure that there is sufficient compliance. What is it that one should do on day one? What is it that one should take care going forward, etc. Siddharth is taking lead on DEPA initiative of iSPIRT. I will actually leave it to Siddharth to explain once we are a bit deep into this session as to what is DEPA, how GDPR sort of interplays with DEPA, and what are the privacy concerns in India that should be probably taken care of in light of DEPA. So we'll start with some preliminary background of GDPR, what it is, and I'll ask my first question to Supratim to explain to us what is this GDPR, how does it impact us, and why should we be worried about it?
Right. If you look globally, what has happened is several countries have now woken up to the situation where technology has gone far beyond the law. The law is lagging far behind.
Sure.
And now we are realizing that this private personal data is all out in the open, unregulated. It's a difficult situation for governments to really handle. So therefore, several countries are coming up with their law. Now, European Union already had legislation, but what happened is, A, it was dissipated, B, it was not enforced as strictly. So therefore, the earlier data protection directive, which was there, it kind of finally has now given way to GDPR, which is.
So help me understand. I thought there was always a data protection law in the US and the EU.
Yes. So they were, what has happened. Regulators, like I was mentioning, regulators have realized that enforcement has been an issue in the past. So, and technology has gone far ahead in time. Therefore, they need to beef up the situation and give up to the situation and beef up their regulation. Therefore, this is basically to address four situations. One is to harmonize the law across the EU, to keep pace with the technological changes that are happening, to ensure that there is free flow of this personal information within the EU territory, and most importantly, to give back control to individuals on their personal data. Okay, so these are the four principles really is based on.
Understood. And Siddharth, will you tell us something about what DEPA is?
Yeah, so worldwide, a lot of countries have actually been looking at things purely from the perspective of data protection.
Yeah.
And that's, again, what GDPR is about, right? General data protection regulation. And what we feel is while data protection is extremely important, so is data empowerment. That is, users must have the ability to have control over their data and share it so that they can gain access to better financial services, healthcare, etc. So basically, they can be empowered through value delivered through the services. So DEPA is nothing but the data empowerment and protection architecture. What earlier was referred to as the consent layer of the India stack. And what we did is we designed something known as electronic data consent about 2 years back, which is now a Ministry of IT standard. Which is, let's say, I'm giving an individual control over their data. What that means is he must have the ability to share it with another organization who is giving him access to some services. Now, there are various parameters to sharing your data. What data you're sharing, with whom, for what time period, how long can they store it, what's the purpose, etc. And so we codified all of this into something known as the Electronic Consent artifact, which is a mighty standard and was adopted by RBI late 2016 into something known as their account aggregator policy.
Sure.
And so the account aggregator was a collective decision by all four financial sector regulators, that is RBI, SEBI, BFRDA and IRDA. So it covers the entire spectrum of financial information under these four, under entities regulated by these four FSRs. And very simply put, it means going forward. And it's getting operationalized as we speak. Technical standards will come out. Companies have already received licenses to become account aggregators, and so they're building out their tech. And what it very simply means is, going forward, Indians have absolute control over their financial information, and they'll be able to share it to gain access to new data-driven services, be it lending, wealth management, reconciliation, etc. It applies both to individuals as well as businesses. We both have data. And therefore, what we have found is India has come up with this very unique institution model of a data fiduciary. Because the account aggregator, by policy, cannot make money from your data. Like, say, an ad company, like Facebook, would be mining your data to personalize ads. In this case, the account aggregator's sole business model is primarily working in the user's best interest. So it's a fiduciary responsibility.
So where do they make their money then?
Primarily from delivering better consent management services to the users. So creating a more informed consent experience and all of that. And we expect a similar model to be replicated in healthcare as well as in telecom data.
Is it operationalized anywhere in the world right now?
There's a sliver of this in the EU as part of the PSD2 directive. As part of PSD2, you have an entity called the iSPIRT, Account Information Service Provider. But that's far more limited in scope. That is, it only covers payment accounts and stuff like that. So if you look at the institution architecture of a data fiduciary, along with the scope of the account aggregator today, there's no other parallel of this anywhere else in the world.
And how would a privacy law such as GDPR impact this data fiduciary or what this concept is?
No, it wouldn't really impact directly, I think, except for entities who have EU users' data, and then Subratin will talk more about that. But this is primarily focused on India and Indian users at this point.
But we will at some point need a privacy law of our own to take care of this data which is held by a fiduciary.
No, so the fiduciary cannot store data.
It cannot store.
It's just a pass-through of managing users' consent. Because when you say control, how do you give them control, right? Control is abstract. So the way we're giving them control is there's an institution like a data fiduciary, which in the financial sector is the account aggregator, who's managing users' consent, allowing them to share their data from their bank account with a lending company, machine readable, digitally signed, so structured, trusted.
So they're just intermediaries
They're just intermediary who's facilitating this data. It's end-to-end encrypted, so even if they want, they can't read it. But the policy also talks about they can't store it.
So ultimately, the person who is receiving data through this intermediary is the one who will be liable to comply with the standards.
Yes, that's correct. So India will have, and we are as part of the Justice Shri Krishna Committee, there is work being done on the larger privacy framework, because there are various data sets. If you classify it, typically it would fall under, say, government data, regulated data sets, which is, say, in healthcare, finance sector, etc. And then also private data sets, right? So private companies, startups, all of that, unregulated folks, which also have and are generating customer data. And so really the privacy law is important because they'll start fundamentally by laying down a set of principles which will empower in the regulated arenas those corresponding regulators to push out directives. Because you want to design something that's evolvable, right?
Absolutely.
What you're seeing is worldwide, why is EU having to revise its privacy laws and stuff like that? Is because it's not evolving in the pace of technology.
Sure.
And the only way you can construct a system is you lay down a set of principles which, if violated, lead to extreme privacy harms and all of that, and then empower other institutions to go more prescriptive. And so in this case, the financial sector regulators have kind of been at the forefront of this, much ahead of the curve, because account aggregator came out late 2016. But yeah.
Sure. Just
one point before we just move on. I think the new draft digital health data related law which came out, DISHA, I think it tries to capture this concept in a way. Of course, we'll have to see how it evolves, but I think it captures in essence.
Sure. And just to go back to GDPR discussion for a minute, now we understand where we are evolving to in terms of financial data and consent data. But presently, companies which are in India and they're looking out, say, for a EU customer, they may not be looking out for a EU customer, but they generally their websites are one can access their websites from EU. One can place orders on their websites from EU. They may have EU customers. Now, how does GDPR impact them, and what are the must-do things that they should keep in mind today?
Right. So, of course, let's understand when is GDPR really applicable to. If there is involvement of personal data of data subjects who are in the EU, it gets triggered in primarily three scenarios. One is if you have an entity presence in the EU, or you're providing goods and services to EU data subjects, whether they are paid for or not, and if you're tracking data subjects in the EU. Now, many people come in the third bracket also
Correct.
because of apps and websites which are tracking.
So suppose I have a website and somebody sitting in the EU can open the website, and usually you have cookies which
Right.
will probably track the user behavior. So would that also come?
So it's still evolving. Okay, the thought process is still evolving. However, the initial understanding at present is that if you have a generic global website, which is say purely just viewable from every jurisdiction, it's still fine. But if you have specifics such as it is translated or it is also available in one of the EU languages, apart from English, of course, or you can make payments in European currency. So on and so forth. So basically, what happens is these layers further make it very clear that you're trying to have business interest or are providing goods and services to the data subjects in the EU, and therefore you come under the purview of the EU GDPR. But what we observe right now in the market is that people are trying to be a little more conservative, considering that the law is new, it's still evolving. And on day one, you saw there were like 8.8 billion USD lawsuits which were filed against some of the tech giants.
Facebook.
Yeah. So therefore, people became suddenly very skeptical that, okay, this is for real. And, we could be hit hard. Let us assess whether we have the exposure. Are we required to follow GDPR? Now, coming to the second part of your answer, basically, if you are hit by GDPR, if you have to follow GDPR, what should you do? From our experience, the toughest task that any organization has to take up is data mapping. Realizing where the personal data lies, how it came, to whom it is going, where all, and in what manner it is getting processed. Once you have the understanding of this, the life is easier, okay, on the GDPR front. Because the rest of it is putting in the smoke from where they obtained this, etc., etc.
So let's break it up. If you are obtaining data from the EU, that is a problem, right? And why would a company not know where it is obtaining data?
I'll tell you why. Because, for example, a mailing list, okay? You could have normal business, say, individual going to some conferences, picking up normal, visiting cards, and therefore you obtained that information. No one really pegged it or plugged it that this is the way it's coming to our database. It is just stacked up, difficult to differentiate. Because under the EU GDPR also, this is very interesting to note, that there are several avenues because of which you can do processing. One is consent, or I have a legitimate interest to provide you certain information. I can readily send you through an email, there is no problem. But suppose I'm sending a marketing mailer, and you and I had maybe 10 years back met it to send you this marketing mailer. The organizations, the primary problem they're facing is they have never segregated in the past the information in this manner, that how did it come to my database? Therefore, the problem lies that they have to send this consent to almost the entire set of people.
Which is what we've all been receiving today.
Yes. And the response rate is very low. So maybe 1% have responded back. So effectively, they have killed 99% of their database.
Understood.
But if they had that segregation, that, okay, I can process data, say, of these many people for legitimate interests that, because maybe you and me, we are dealing with a particular media subject. You would like to know more, you have such inclination and you've indicated in some manner. I have sent you some mailer. That's fine. Or we have a contractual arrangement, we are working on the same subject, and therefore I sent you something. It's perfectly legitimate, and it's a contractual obligation also. But suppose we never thought of this particular, say when we are discussing on media and I sent you something which is, say, of a completely different nature, okay, that kind of a mailer, it might be obnoxious for you. And believe me, the end customer facing businesses can get hit the hardest. Because there you need to understand that this right has already been granted to the data subjects in the EU. If a person gets annoyed by a mailer that you have sent, the person can actually take you to task.
Okay.
Therefore, these businesses are more in the risk zone.
And there is no plea of ignorance that I did not know. I could not have known that my subject who I'm sending the email to is in EU.
Not really.
There is no plea on
this.
Okay.
So just building on that, what I've been seeing is a lot of product and services companies that indirectly happen to have EU users are blanketly shutting it off.
Yes.
So I just want to know, your thoughts on that versus, given that the high cost of compliance, you just find it easier to block it, and hence EU users, it's a form of disservice in many ways. But what are your thoughts?
No, actually, this has come to the forefront that this seems to be the easiest way out right now. When people are still grappling, the law is still evolving. Therefore, no one wants to take a chance because this one-off notices can also shake up the organization. Maybe it's just 1% of their revenue, so it's better to shut off the link. That's how some organizations are approaching this as of now.
But does that still serve the purpose? Suppose I have an email ID and I am an EU resident, and how do you ensure that nobody in the EU receives your email, which you are sending it out to all your customers? How do you put that blanket block? When you say that organizations are just...
No, I think what it means is basically, if a website is viewable from other jurisdictions, the shutting off is happening at the IP level. You're blocking it for you.
It's obviously not 100%, but
sure, you can at IP level block somebody accessing your website, but your emails, how do you block them? How do you segregate?
No, so on the email front, again, I am not getting into the trickier zone because it says data subject in the EU.
Sure,
okay?
Yeah,
it doesn't say resident, citizen. So I'm not getting into that discussion. But the point here would be that at least if you have fair sense of these set of people are from the EU, if you do not know, best thing is to take proper explicit and informed consent the way it is provided in the GDPR. If not, not to proceed.
So shutting down is one thing for the EU. You can probably shut down, and that's easier part, right? And people are doing it. People who can afford it, maybe for their business is good. But people who cannot afford it and who need to continue with their business operations in the EU, so what do they should do right now?
So again, I would go back to the earlier point. The task starts with realization of personal data.
Sure.
Data mapping. Okay. This data inventory creation or data mapping is a critical numero uno. I think they need to understand where it resides, how it is moving, how it is getting processed. Then we go on to the next steps of we build around policies and practices around it.
So assume that in the first step, I have found certain number of people sitting in the EU who I interact with, right? Then you are saying I need to create some policies for them?
Yes. So the policies have to be there, which is compliant with GDPR. What is critical is also that you need to understand EU data subjects are getting certain special rights.
Okay.
When you are reaching out to them, then you'll have to tell them that you have special rights to access your data, edit your data, have your data ported out or erase your data, object, restrict processing, limit profiling, all of these rights that have been given.
Which we were talking about DEPA here.
So these things, then you'll have to sort of, actually have in place. Because, what I saw in India is someone came to us on 23rd, many organizations actually near to 25th. They came to us and said, GDPR is coming into effect. We have 2-3 days, just frame these policies and we are through. So on 24th or 25th, I am GDPR compliant. So we have to really counsel them. This is not GDPR compliance. It means actual practice.
So that is most important for this session also.
Yeah.
What is it other than policies? And policies is something maybe we can do a separate session on in itself. But one is policies, and policies need to comply with. And I understand that there are multiple policies.
Yes.
Just to put this on record, there's no, like, it's not privacy policy, TNCs, and,
Yes,
and
absolutely.
so there are multiple policies that one needs to take care of. And I assume there is no template available anywhere one can use, or is it?
See, I would say there are several available, but point is that we have to be very careful because under the name of GDPR compliant policies, many people are rolling out many different kind of documents. But one has to be very careful as to whether they are actually compliant with or contain all the parameters that are set out in the GDPR and accordingly use it.
So that's about the policy, and other than policy, you're saying that we need certain processes in between.
Yes, so it's similarly. So what you write in policy is not about writing about it. So like I told you, like right of erasure, for example. If someone comes back to you and says that I don't want my data to be kept with you, so you should know that, okay, apart from certain avenues that you will have to actually delete it and not use it any further. Then, right of editing their personal information, all these things. So these are...
Basically, what he's trying to say is data governance is going to become extremely important in the GDPR context. And so a lot of these policies now need to be codified at your database level.
And I need to develop tech for it.
Yes,
I need to put engineers to the task and ask them that, look, I need erasing capacity.
Yes.
There are companies offering these data governance solutions already, but
there's a huge compliance burden for companies who are maybe starting off, right? And sure. So that's the second layer of it. Is there a third layer also? Or?
So apart from that, depending on what kind of data you are processing, you might have additional stuffs like having a data protection officer or a representative in the EU. Whether you are actually
you need an officer in the EU.
You need so there are two different buckets. One is a data protection officer, and the other one is a representative who's in the EU. Of course, there are specified buckets for that. If you are falling in those buckets, then only you would need to really have them, not otherwise.
Otherwise, a grievance officer under the IT Act you have in India, he will probably take care of it. Any particular concerns that are maybe recurring in Indian companies' cases when you have dealt with them?
So, as I was mentioning, the foremost one is, I think, database where people would have sent marketing mails and advertising or marketing related mailers or product related information in a subsequent to their initial interaction maybe with the people, the clients. Today they are a little lost, and what has effectively happened is the database has got killed
until they map everyone and take everyone's consent.
Either consent has been taken, or you are able to identify that from A to F there are certain parameters given in that particular article. If you are fitting into any of these, then only you can proceed to processing of that. Number one is, of course, consent. The other relevant ones are A, contractual obligation, and legitimate purpose. The problem with legitimate purpose is a person to whom you are sending can always sort of revoke that and say that, okay, it has actually. So it is worded in a manner which can actually bite you back if the other person doesn't think that likewise. So while some organizations are taking help of legitimate purpose and processing, they have to be very clear and circumspect about this whole activity, because if one of those, say, individuals whose data they are processing doesn't agree, doesn't think otherwise, likewise, then there's a problem.
And just in terms of enforcement, I know I'm thinking a bit too far maybe, but how does a company based out of Koramangala and Bangalore care about a law in the EU? Like, how do they probably, care about enforcement?
Yeah, so, this discussion has been going on, and the thought process is that unless you have treaties to really enforce, it would be not possible. But I would say businesses with EU linkages, whether, say, if your controller is sitting there and you're just a processor here, it will be a top-down effect. Okay, so
maybe between EU and the US, suppose I don't have any, say, business assets in the EU, but if I have business assets in the US, then also maybe it'll be easier for them to go after my assets in the US, because I'm sure EU and US will have better.
Depends, and one has to see how this rolls out. But nonetheless, many people were sitting on the fence because of that actually.
Okay.
Until that Facebook case, really erupted on day one,
sure,
and showed that there is a real possibility of things happening. People have now sat up and they're thinking maybe it is a reality, and enforcement could also be a reality.
Understood. And so far we have discussed about consumer-facing businesses. But what about B2B businesses? How much impact would they probably see because of this?
See, again, it all boils down to personal data. Okay, what kind of personal data is being?
And let's spend a minute there. What is personal data? Like, if I'm giving you my official details in an official meeting, and pursuant to that we do business together, like, what part will fall under personal, what will not?
See, your email ID would fall under personal.
Even my office email ID?
Yes. But, there, what I mentioned to you, that avenues such as business contract, contractual arrangement,
sure,
legitimate interest plays a very important role, because it is really legitimate for both two people. If they're doing business, they ought to transact or interact, and therefore personal information is being processed. But minus that, if people try and go over and beyond and try to do marketing, etc., that too.
So marketing email from a business to another business, from a business in India to another business in the EU, is also not permissible without consent, or is it?
So,
or is it gray?
If it is gray, because you would be sending to some person, not to a organization's email ID. It would be hitting some individual's or person's email.
Understood. So if I send to somebody email ID who may be working in a law firm there, although we are dealing as a lawyer to lawyer or a businessman to businessman, it may still fall foul of the GDPR.
But I must just caution everyone here that several aspects of GDPR are still evolving. Okay, on the legal front, and we see that even foreign law firms, they disagree on certain aspects. Okay, they are not seeing. But the idea is to, at this hour, is to take the most conservative view and approach the subject.
And also, if I could just jot down for our viewers here, what is the bare minimum that one has to do? Obviously, all this compliance cannot be done even by bigger companies day one, and I'm sure in your experience in advising them, you would have faced that even bigger companies are sort of unable to comply with all these infrastructural requirements. So, smaller companies who are starting up or who are in early phase of growth, what is the bare minimum that they should do at the very least to sort of ensure that, okay, there is some level of compliance?
So, as you correctly mentioned, demonstrating compliance under EU GDPR is very important. And in several forums when we have discussed, people are of the view that it's not that the regulator will be, coming after you after 25th, and on day one they will be say, okay, this is the penalty that I will the highest penalty would be meted out. Idea is to also see that you should have started the journey, because that under GDPR there is fair amount of delegated legislation which is permitted. Okay,
sure.
So member states are actually given the leeway that they can frame laws for certain of these avenues. Now, therefore, idea is to start the journey, and I think. Apologies, but I will just go back to my earlier point, which I thought is the most critical one. Even if you're a small business, identify the personal data of EU data subjects, understand how it came, where it is kept, how it is moving, where it is getting processed, understand what are the policies that you should draft, and pursuant to that, in what you're writing is actually correct. You're creating avenue for a EU data subject to actually approach you, get their data rectified, erased, etc. So you have the processes in place. Data security is taken care of. See if you need a data protection officer or a EU representative. And I think this is a good enough starting point.
So, Supratim, where do we go from here? So today, we have just told everyone that just figure out who your customers are, who are you sending emails to, map your data properly and figure out what you need to do or whether you need to be worried about it or not. So what is the next step? We do all of it, and then is there an expectation that probably there'll be some more clarity on some of these aspects?
Yes, as days pass, there will be more clarity on this. And I'm actually encouraging Indian clients to start this journey as soon as possible, or, get into it, because when we went through the consultation sessions of Justice Sri Krishna, went through the white paper that was floated, we realized that significant number of principles would be taken from the GDPR bill. So if you are making your organization compliant with this, you are actually making your organization future ready for the Indian law as well.
Including DEPA.
Yeah.
So
DEPA is not a law.
Absolutely, but
DEPA is a tech framework.
But it enables you to implement some of those things.
Yeah.
If you have already taken care of. So
the principles remain the same. So at DEPA's principles, primarily what we refer to as organs. So based on open APIs, consent is revocable, consent is granular. So the electronic consent artifact actually codifies things like he was mentioning, purpose codes, all of that stuff. It's auditable, so that you can peg accountability in case fraud takes place. The user is notified. So let's say when he shares his financial data, just like when money leaves my account, whenever I share my data, I get notified via SMS. And it's obviously secure.
Sure.
So the principles actually across seem to be very, very similar.
So one has to, there is no denying the fact that one has to get into this, and
sooner the better.
Sure. Maybe we will do another session on Justice Sri Krishna committee report, and we are, I think, at the last leg of this drafting and implementation of this bill. So maybe we will spend some time in the next session on how GDPR is sort of going to, not going to, but it has already impacted the law framework in India. So we'll probably spend some time on that and see whether there's anything additional that Indian companies need to worry about their Indian customers.
Sure.
Sure. Thank you, Siddharth.
Yeah.
Thank you, Shubhro.